Hey, friends, welcome back to the Think Tank. So, we had a busy morning this morning with all of the Murdoch stuff. He was having to face all of the people, well, some of the people that he burned. There's that. And we also looked at, well, where he stands. It looks like he ended up with an added 27 years, is all. Not a lot in my mind. So we dealt with that all morning. Hello, Dandy. Welcome back. So, yeah, this time we're going to talk about Judge Fran Gull and Richard Allen. Two more documents came out. So I thought maybe we would take a look at them. I'm going to go through them based on interest. If it looks like you guys really, really are not all of that interested in it, then we probably won't even bother going through it all. But to me, it's interesting. I mean, any documents coming from the court right now, when it comes to Judge Gull, I think is important to go over. She has been dealing with all of this in a very strange way, if you ask me. I've just never seen such an ish show, you know? So yeah, I thought we would go through these and play it by ear because I can always, if people aren't interested in seeing it, I'll put these in either way. I'll put them in Patreon for anybody to grab if you want them. They're both about 20 pages, these ones. Still hanging in there, eh, Dandy? You're so awesome. So we'll get right into this. On top of doing all this, we're trying to get our 24 days of Christmas done. So I think I'm going to be up until tomorrow. I had no idea I was going to be that busy with Murdoch. But seriously, check it out. It's unreal. Unreal. It's typical Murdoch. So this one here is Richard Allen versus Carroll, Circuit County, and the Honorable Francis C. Gull. No idea who that is. No idea. Sorry, guys. Okay, sorry about that, guys. Attorney General's response to Realtors Richard Allen's petition for a writ of mandamus. Table of contents again. Yipes. Oh, yipes. Yipes. Whoa. Looks like it's going to be jam-packed, right? All right. Give me 2 seconds here. I'll get hydrated and we'll be good to go. Yeah, I didn't expect all that to go on this morning. I was quite surprised. And I was quite surprised at how long Alec Murdoch talked. It was like, what? Ole. So to me, it just seemed like he was setting up for a possible appeal in the M case. We'll have to see what happens. Okay, so the background. In 2017, 2 girls were M'd near the Monon High Bridge Trail in Delphi, Indiana. Richard Allen was charged with the M's on October 28th, 2022. This just came out of nowhere. Remember, all of a sudden it was just boom. There was this guy that they had arrested. It happened fast. On November 14th, 2022, Special Judge Francis Gull appointed Bradley Rossi, Andrew Baldwin to represent Allen. In October 2023, discovery subject to a protective order was leaked to the public. On October 12, 2023, Attorney Rossi wrote to the court acknowledging that the defense was the source of the leak and arguing that disqualification of attorneys Rossi and Baldwin was not the appropriate remedy. Judge Gull set a hearing for October 19th, 2023 to discuss the upcoming hearing on October 31st, 2023, and other matters which have arisen. Baldwin retained attorney for the hearing, and that attorney filed a memorandum regarding possible disqualifications or sanctions. This right here is what all of this show is about. It's almost, to me, as soon as they came out with all the Odinists and Odinism, that this is what ended up happening. This seems to be the repercussions from that, in my personal opinion, of course. So at a chambers meeting before the hearing, Judge Gull informed Baldwin and Rozzi of her concerns regarding the defense's team and the totality of the circumstances surrounding your representation of Mr. Allen. Judge Gull outlined her concerns. So now this is where basically they're saying that they were ganged up on. They were jumped, basically. They had no idea what was going to happen this day. They basically thought they were going in there to work on some of the details as far as this leak, but it did turn into something else. Okay, so response to the realtor's petition. Improper comments to the public. After stating they would not talk about the case, Baldwin and Rozzi issued a press release that was potentially violative of ethic rules. Conflict of interest. Rozzi filed a tort claim on Allen's behalf against the DOC, Department of Corrections. Protective order violation. Baldwin negligently released discovery to Brandon Woodhouse, who disseminated it to the public. Baldwin did not alert the court or the state to release. So there's a lot of things in here that Judge Gull has some explaining to do. Filing motions with inaccuracies and falsehoods. The pleadings regarding the safekeeping Allen in the DOC contained proven false information. So again, this seems to be coming from her. Protective order violation. Baldwin was the source of more leaked discovery, which spawned a criminal investigation and may have resulted in an unaliving. Judge Gull found that Baldwin and Rozzi had demonstrated gross negligence and incompetence in representing Allen. Judge Gull stated she did not want to say this in open court, but would if she had to. Judge Gull confirmed that Baldwin and Rozzi did not withdraw. She would have removed them. After consultation with Allen, Baldwin and Rozzi chose to withdraw. When withdrawing their appearances, Baldwin and Rozzi claimed it was unfair because they were forced between an accused and misconduct in open court or withdrawing. In open court, without Baldwin and Rozzi present, Judge Gull announced they had withdrawn. I'm going to check over here for a second, guys. Okay. Rozzi tendered 2 documents on October 25th, 2023, a notice that he was still Allen's attorney and a motion to disqualify the judge. Judge Gull took no action on these filings because Rozzi was no longer counsel of record. On October 27, 2023, Baldwin's attorney, David Hennessy, filed a motion to reconsider, claiming that there had been no valid motions to withdraw by appointed counsel. On October 27, 2023, Judge Gull appointed 2 new attorneys to represent Allen. At a hearing on October 31st, 2023, Baldwin and Rozzi were present, having tendered appearance the day before. Hennessy also appeared for Baldwin. Baldwin or Rossi did not attempt to represent evidence to rebut Judge Gull's factual findings, findings that nothing had altered the court's concerns about counsel's gross negligence. Judge Gull disqualified Baldwin and Rossi from representing Allen. Hennessy withdrew his appearance that day. No attempt was made to appeal Judge Gull's order. On November 6, 2023, attorneys Kara Weineck and Mark Lieben filed a petition for writ of mandamus, with the court asking the court to order the trial court to reinstate attorneys Baldwin and Rossi, to order the trial to be held with 7 days of the granting of the writ. I'm just gonna look here. Do we have I don't know what I think of this. I think there was probably a better way to do this. Just my opinion. Okay, so an original action is a limited remedy governed by strict procedural rules. Original actions are viewed with disfavor and may not be used to substitute appeals. Before a writ will be entertained, the realtor must raise the question by written motion to the trial court. If remedy by way of appeal is full and adequate, a party may not invoke the jurisdiction of the court under original action rules. A writ of mandamus will not issue unless the realtor has a clear and unquestioned right to relief, and the respondents have failed to perform a clear, absolute, and imperative duty by law. There's a lot of very, very questionable things, isn't there? A writ of mandamus reinstating Ellen's former attorneys is not presently warranted. The conditions precedent for a writ are not satisfied, as the claim was not clearly presented to the trial court, and a remedy by appeal is adequate. Even where the court to review the merits of Ellen's request, the record is not sufficiently developed for the court to resolve the question. Wowza. A. Appeal is both adequate and preferred to review whether a trial court abused its discretion in removing counsel. Ellen did not seek oh my word, here we go. I had problems with that word earlier. Appeal of either the trial court's order granting withdrawal or of counsel, or its subsequent order declined to allow counsel to appear pro bono. The record does not indicate that Allen asked his newly appointed counsel to appeal. Oh my God. Nor does realtor explain why original action counsel could not file a limited appearance to seek certification of the court's order, as counsel did to file motions in preparation of this action. The writ of mandamus cannot be used as a substitute for appeal. This decision could have been appealed. Disqualification of counsel can be required, or it can be at the discretion of the trial court. The extraordinary remedy of a writ is not available where the matter is within discretion of the trial court. An action for mandate may not employed to adjudicate and establish a right or define and impose a duty. Though this court has reviewed disqualification of counsel through original actions, the court has not issued a writ to reverse the trial court's discretionary removal of counsel, but has issued writs where counsel continued representation exceeding statutory authority, granting a writ to disqualify special prosecutor under statute, granting writ to remove private counsel retained for state agency in violation of statute, denying writs to reinstate disqualified attorneys where attorneys requested to withdraw if not granted a certain motion. But the appellate courts have reviewed discretionary removal of counsel, though appeal. I just can't wrap my tongue around that one. I don't know why. Reviewing disqualification of counsel for conflict of interest. Removal here was at the discretion of the trial court, so mandamus is inappropriate. She's having lots to say right now. Allen does not identify an absolute duty to reject counsel's withdrawal or to permit them to reinstate representation. How do you think this is going to fall? Do you think she's making points here or making a fool here? Okay, give me a second here, guys. Again, we are forgetting, due to everything that's going on, what this case is about. It is so sad. Abby and Libby. We're still waiting for justice. You know, if this guy is the guy, prove it and let's get on with it. Do something about this ish show that's happening in the courtroom and behind, and let's deal with the problem at hand. Is Richard Allen bridge guy? You know what I mean? Is he? If he's not, they got some explaining to do, right? Jishka Bibble. Okay, let's get back into this. 2 more seconds. The law does not place an absolute duty upon courts not to interfere with the attorney-client relationship, but it bars arbitrary and unjustified interference. Allen contends that respondent acted to terminate the attorney-client relationship when she had an absolute duty to refrain from doing so. But Allen does not identify the origin of this absolute duty. Allen's brief does not contain the verbatim statement of the relevant parts of all cases, statutes, and other authorities relied on, required by the rules. Such a statement is necessary to define the source and scope of the duty that Allen seeks to mandate. A trial court's authority to remove counsel is more nuanced and less absolute than Allen suggests. The right to choose counsel and continue representation is not absolute. The Sixth Amendment guarantees every defendant the assistance of counsel. Those who do not need counsel appointed also have a constitutional right to choose counsel, but indigent defendants do not have the right to choose appointed counsel. The United States Supreme Court has not recognized for appointed or retained counsel a distinct right to continuity of representation, and the court has rejected a constitutional right to a meaningful relationship with counsel. But the Sixth Amendment proposes of ensuring a fair trial, imposes a baseline requirement of competence on whether lawyer is chosen or appointed. The right to choose counsel is not absolute. While the right to select and be represented by one's preferred attorney is comprehended by the Sixth Amendment, the essential aim of the amendment is to guarantee an effective advocate for each criminal defendant, rather than ensure that a defendant will inexorably be represented by the lawyer whom he prefers. But for retained counsel, courts must recognize a presumption in favor of the defendant's counsel of choice. Indiana has not addressed whether the distinction between retained and appointed counsel alters a court's authority to substitute counsel, and authority is mixed in other jurisdictions. You know, we all seen, I mean, I don't know this woman, Elaine something or other, but I did see her on the Amber Heard trial. So you want to talk, in my personal opinion, about incompetence? I mean, I suppose she was doing her job, but to me, just my personal opinion, she sat there looking stunned most of the time. So if you've got someone, in my personal opinion, that is like a crappy lawyer, does that give you a right to get rid of them? I'm really curious on how they decide to deal with Rozzy, because this was not his office, this was not his leak. He's not even in that building. So, how this judge decided it would be okay to let them both go, I haven't figured out yet. Does she make any good points? Well, maybe. I don't know. I don't know what I think of her. I don't get the warm fuzzies. Okay, let's see here. Mm-mm-mm-mm. Trial courts must give great weight to a defendant's preference, whether requiring a presumption or weighty consideration. Trial courts must weigh a defendant's preference for representation against the circumstances favoring disqualification. Mhm. Yeah, so nothing has been established as to whether what she did was lawful or unfair. Yeah, I don't know how this is gonna work out. I mean, I don't I'm not a lawyer, but just from a layman's view, she's horrible. She's horrible. But you know what? I'm not a lawyer for a really good reason. I can't deal with unethical people. So, contrary to Allen's claims, more than two circumstances may require a court to interfere with a defendant's presence for counsel. As Allen recognizes, a defendant cannot insist upon counsel who is not admitted to practice, and a court may act to remove counsel when the representation creates an actual or serious potential for a conflict of interest, including refusing to permit the defendant to waive the conflict. So, as I'm reading this, was there not a leak out of Judge Gull's office? I do believe. I'll have to verify that, but it's back there in the memory banks where I do believe that something was leaked from there as well. Counsel's conduct or personal circumstances may justify removal. Gross incompetence or physical incapacity of counsel or uh, hmm, or conduct that cannot be cured by a citation for contempt may justify the court's removal of an attorney, even over defendant's objection. A trial court may disqualify an attorney's representation before the court, and a defendant may not insist on counsel of an attorney who has a previous or ongoing relationship with opposing party, even if the opposing party is the government. Holding defense counsel should be disqualified where representation violated duty of confidence to former client, the state. Well, they're not talking about the mess ups that the state has made, you know? Of course they're not. This is coming from her side. It's just, what a disgrace. What makes me sick to my stomach. Oh my God. Good to see you, Mexi. So courts must also balance the need of public and victims. The general public and victims of crime also have an interest in the even-handed administration of justice. Trial courts have the discretion to balance these interests with the defendant's desire to be represented by his preferred counsel. We reviewed the disqualification counsel for abuse of discretion. Though varied interests may necessitate overriding a defendant's preference, disqualification is an extreme remedy that should only be used when the court deems it responsibly necessary to ensure the integrity of the fact-finding process, the fairness or appearance of fairness of trial, the orderly and efficient administration of justice, or public trust or confidence in the criminal justice system. So, what do you guys think Fran Gull has done for the system lately? Do you think she's making it look shiny and perfect? Or do you think maybe she's pointing out, just by her behavior, all the mess ups, all the underhanded, looks underhanded, at least stuff that we're seeing? This is just not about the girls anymore. This is about Francis frickin' Gull. Wow. Yeah, it's nauseating. So, defense counsel's withdrawal, truncated, oh my word. The proceedings and the present record prohibits complete review of whether the trial court's concerns justified substitution of counsel in chambers prior to October 9th's hearing. The court listed reasons it found counsel should be disqualified that it intended to address at the hearing. The prosecutor was prepared. Oh, wasn't he? The prosecutor was prepared to present evidence from the leak investigation, but this hearing did not occur because counsel defense withdrew rather than challenge the factual allegations at the time. Oh my God, this is just sneaky, sneaky, sneaky. Oh la la. At the October 31st hearing where Baldwin and Arazi attempted to appear for Mr. Allen and had their own counsel, no additional evidence was offered or arguments made to rebut the court's allegations. But you know what? I think they tried. I do believe they tried. She was cutting off their voice. Good to see you, Shauna. So, respondents raised concerns that could warrant disqualification depending on the circumstances. The court's concerns raised questions regarding counsel's compliance with professional ethics and ability to provide Allen effective representation. After the state sought a gag order, counsel had assured the county that they did not intend to try the case in the media, but then issued a detailed press release challenging specific evidence that the court believed violated Professional Conduct Rule 3.6. The restrictions on publicity, commenting on specific evidence, and related limits on pretrial publicity exist to protect the defendant's right to a fair trial and the availability of an impartial jury. I still think they can get an impartial jury. I don't really see where there's a problem with that, but what do I know? I appreciate you guys. I really do. So the court expressed concern about the counsel's candor. Baldwin informed no one that a defense outline had been sent to a third party for months until the state discovered it. The court noted prior filings appeared to make factual allegations without foundation, which were then disproven. The record does not contain the transcripts necessary to evaluate those concerns, but the concerns raised potential ethical issues and concerns for competent representation. Noting attorneys may not make false or misleading statements to the tribunal, and such conduct may be prejudicial to the administration of justice. So, what is she talking about here? What do you think? Do you think she's talking about the Odinism stuff? I'm just curious. Counsel's conduct could implicate a conflict of interest or endanger Allen's ability to secure an impartial jury. Defense counsel permits 2 separate leaks of protected material, including graphic crime scene images. Public dissemination of graphic crime scene images could inflame prejudice against Allen because of the extraordinary public attention on the trial. The court imposed a strict protective order on all discovery. The records contained incomplete and inconsistent information regarding the extent of the leaks and counsel's role in them. An affidavit from a friend and former employee of Baldwin claims responsibility for taking the photos without counsel's knowledge. But a letter from counsel to the court indicates that counsel regularly consulted the same friend about the case and defense strategy. It's unclear whether the friend was given access to protected discovery or privileged information during these consultations. The record also does not reveal what law enforcement learned about the extent of the leak or counsel's role in it, and the investigation appears to be ongoing. Investigations into the potential liability for counsel's conduct during representation can give rise to a conflict of interest requiring removal. The court also expressed concerns that counsel obtained a financial interest in the proceedings by filing a notice of tort claim related to Allen's pretrial confinement. Whether circumstances exist that would divide counsel's loyalty between Allen and their own interests is unclear. The record is also inadequate for full consideration of Allen's preferences. The record contains expressions of Allen's desire to retain Baldwin and Rozzi after being informed of the leak, but the record does not show what Allen knew or understood regarding the leak. The court's other concerns about counsel's competence, how those matters impacted his ability to obtain a fair trial, or the alternatives available to him taken as true. The existing assertions of Allen's preferences are insufficient to determine that he is making an informed decision. The presumption of defense to the defendant's choice is strengthened by confidence that it is an informed and individual choice by the defendant. Inquiry and advisements from the court are needed to ensure Allen understands the risk and gains of his choice. The court's discretionary decision could be reviewed on appeal, but the limited review of the action is inappropriate. Courts had discretion to remove counsel for gross incompetence or appropriate conduct that cannot be adequately addressed through contempt. Wow. This requires more than general concerns that counsel is not handling the case as well as they should. But the extraordinary remedy of a writ is not available where the matter is written within the discretion of the trial court. This is such a case. Allen has not asked this court to mandate further proceedings, but an outcome. Allen seeks a combination of release, reinstatement of counsel, removal of the judge, and a trial within 70 days of the writ. This would not permit respondent or any successor judge to undertake further proceedings prior to trial. This is inappropriate to decide whether the trial court abused its discretion. Writs may issue to compel lower courts to act on matters within their discretion, but they are not appropriate to dictate how the discretion is exercised. The balance between a defendant's ability to choose representation and his right to effective representation warrants comprehensive appellate review and not the expedited and... Okay, guys, how do I pronounce this? Because my tongue does not want to say it. Okay, so let's see here. As a second request for relief, Allen asked the court to order his trial to commence within 70 days of the issuance of the writ. Allen is not moved for an early trial under Indiana Criminal Rule 4. Allen points to the fact that he signed a motion in August 2023 requesting an early trial, that this purposefully had not been filed with the trial court. A trial court cannot act on a motion that has never been presented to it until the trial court has shown by some ruling or refusal to act that is exceeding or failing to exercise its jurisdiction. There is no basis for action. Allen can file a motion for early trial at any time, and the trial court must set the trial date within 70 days. Because Allen has not yet requested an early trial, it is improper for him to ask for this court to order the relief in the first instance. As his third request for relief sought, Allen asked the court judge to remove Gull and appoint a new special judge. This request is improper, as Allen has not asked for this relief from the trial court. It is true that after he withdrew, Rozzi filed a motion to disqualify. However, at the time that Rozzi filed the motion, he was no longer Allen's attorney, so Judge Gull did not take any actions on the motion. Allen cites no authority that the trial court must entertain a motion by an attorney who is not the party's current attorney. By attorney not properly granted pro have vice and nullity. Ellen does not meet the conditions precedent of Rule 2A because Ellen did not first request his relief in writing from the trial court. It is an improper to respect this relief now. Is it improper? Further, Ellen fails to show that remedy by appeal is not adequate. Current counsel could have filed Rosie's motion or sought, man. The appellate process is adequate to correct an issue of the respondent's court's discretion at denying realtor's motion for a change of judge. A writ is inappropriate because Allen has a remedy through his appellate process. He can file his motion for change of judge, and if denied, he can appeal that decision. Finally, Allen, who points to the judge's rulings in his case to argue the judge is biased. This is not sufficient. There were mere assertions that certain adverse rulings by judge constitute bias, and prejudice does not establish the requisite showing of personal bias or prejudice. Even if properly before the court, this record does not support a change of judge. Because of this precise relief requested by Allen for resolution in this original action, this court should deny the writ. There she goes. There she goes. There she blows. So I've got one more document that came out that I thought we would take a look at. Just let me get it set up. It's about the same amount of pages. So this here one, 23 pages, is the Realtor versus Carroll County Circuit Court and the Honorable Francis Judge Gull in the Supreme Court of Indiana. Respondent's brief in opposition to Realtor's verified petition for writ of mandamus. Wow. Okay. Interlocutory. 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 Oh my God. Do you guys have words? Like my tongue just twists. Okay. Yes, she is. Okay, I need liquids. Let's go. I need some Tylenol. Give me 2 seconds. 2 Tylenol tablets, 2 THC tablets. And smoke them if you have them. Winter is ignorant. If you've got anything like arthritis or fibro, or I'm sure a lot of things, but holy shite, has it been ignorant. Interlocutory. Interlocutory? Hey, Tracy. Yeah, we're on our second document for Richard Allen. I think Franky's going to be ordering food in tonight. And I think I'm on December 3rd. And then Polytechnique, December 6th. Slow and steady. Interlocutory. Interlocutory. Okay, interlocutory. I need that word to like just interlocutory. Okay. The court has never issued a writ to reinstate a criminal defendant counsel whom the trial court removed for engaging in multiple acts of gross negligence, causing the trial court to conclude that the accused was not receiving competent representation. In disqualifying Realtor's counsel, respondent did not violate any absolute duty. Moreover, Realtor's remedies are on appeal are wholly adequate. Appellate courts in Indiana and across the country routinely resolve issues regarding a criminal defendant's Sixth Amendment right to counsel of his choice through the ordinary appellate process. Whether the Realtor's counsel withdrew or were removed, this court should deny the petition. Good to see everybody. Good to see y'all. Okay. Realtor's petition further fails on merits. Realtor's Sixth Amendment right to effective assistance of counsel outweighs its limited right to select counsel. Respondent has discretion to remove Realtor's counsel, where, as here, the record supports the attorneys Baldwin and Rossi were providing ineffective assistance of counsel. Realtor's counsel failed on multiple occasions to take reasonable steps to safeguard confidential case materials, made extrajudicial statements that had material likelihood of prejudicing the case, and provided false information to the court before removing Realtor's counsel. Respondent afforded Realtor with notice of opportunity to be heard through written submission as well as an argument in chambers on the record in open court. Oh my. Realtor's request for this court to disqualify respondent fails because respondent alleges no bias or prejudice against Realtor or his current counsel because she picked the current counsel and she eats and snacks with them. Realtor's lone assertion for respondent's removal is the trial court's ruling to disqualify Realtor's prior counsel, but the trial judge's adverse ruling are insufficient to demonstrate the judge has personal bias or prejudice. This court should deny the petition. Okay, I have to look at something. I have to take a look here. Give me 2 seconds. Give me 2 seconds, almost there. Mm-hmm. Mm-hmm. 2 more seconds. Okay, it's not that one. Just about there. 2 seconds. Okay. And we're back. Okay, so the Supreme Court has the power by writ of mandate and prohibition to confine a lower court within its lawful jurisdiction. Writs of mandamus and prohibition are extraordinary remedies which are viewed with disfavor and may not be used as substitute for appeals. This court will not issue a writ unless realtor has a clear, unquestioned right to relief, and only where the trial court has an absolute duty to act or refrain from acting. Argument. Okay, realtor's petition fails the mandatory procedural requirements for seeking a writ. A, realtor does not have a clear, unquestioned right to have his counsel reinstated. What do you guys think of all this? Unreal, friends. The court has never issued a writ to reinstate counsel where, as here, the trial court removed counsel based on the court's reasonable findings that counsel had engaged in multiple acts of gross negligence, compromising the accused's constitutional right to competent assistance of counsel, and contrary to the realtor's assertion, neither this court nor the United States Supreme Court has held that a trial court may remove an accused's selected counsel in 2 circumstances only, where 1, counsel is not a member of the state bar. Well, yeah. Counsel has an actual conflict of interest. Okay. Realtor does not have a clear, unquestioned right to the relief he seeks. To the contrary, this court denied the relief realtor requests here. The realtor, who has been indicted for M and R, requested a writ of mandamus to reinstate his attorneys, whom the trial court had removed. The court denied the petition in dictum, and court observed that it was generally of the view that a criminal court is limited in its authority to remove a criminal defendant, court-appointed counsel. However, the court finds it unnecessary to explicate the perimeters of the authority here. This dictorum, this court's dictum in State ex rel Jones does not provide realtor with a clear, unquestioned right to relief or establish the respondent's violated an absolute duty. Realtor relies for the most part on cases from outside Indiana. See petition. But these cases are not binding on the trial court, much less do they impose on the respondents an absolute duty to act. With interpreting the Sixth Amendment, the trial court must follow the law of Indiana's appellate courts and the United States Supreme Court. Realtor identifies no case from this court or the United States Supreme Court that does afford him a clear right to an extraordinary writ for the relief he seeks. Wow. So we have it. We're not hearing from Richard Allen's side, really, are we? Everything that we've looked the last couple of days has been her responding. Okay. It's been a long day, friends. Alex Murdaugh, hey? Murdoch. Wasn't that something? So what do you guys think is actually going to happen here? Do you think Gull is going to stay and they're going to go? Like, I don't think Baldwin needs to go, personally. Or no, sorry, I got him. Rosie. I don't think Rosie needs to go. Just to keep it fair. I don't see why he has to go. Just because they were working on the case together? I really don't understand why there is all this BS going on behind the scenes. This should be fairly straightforward. It should never have started to go sideways like it has. It's disappointing. There's no way you can go through all of this and not think of Abby and Libby, not think of their grandparents, not to think about Abby's mom, Libby's sister, her mom, her dad, her grandparents, all of this. And meanwhile, we're dealing with an ish show. It's very frustrating because I think she has done a really crappy job of dealing with this situation, but that's just my opinion, We have to figure it out. They have to figure it out. Who is this guy? Is this Richard Allen? Do they have the right damn guy? Figure it out, people. Like, what the hell? Oh my God. Just figure it out. Brutal. Okay, let's see. All petitions shall state facts showing clearly that the remedy by appeal will be wholly inadequate. Original action rule, far too frequently writs of prohibition and mandate are sought to be used as a shortcut to an appeal on the merits, which cannot be done. If Realtor believes that cases from other jurisdictions are pervasive in how respondents should interpret the Sixth Amendment, realtors may present those arguments in interlocutory or direct appeal. Realtor cannot find an original action to circumvent the normal appellate process. Indiana's appellate courts, as well as other state and federal appellate courts, routinely consider Sixth Amendment, amendment challenges on interlocutory on direct appeal, including disputes about choice or removal of counsel. So those cases defeat Realtor's assertion that his remedy available by appeal would be wholly inadequate. Realtors asked this court to use an original action rule for the time in Indiana that the Sixth Amendment prohibits a trial court from removing counsel from the trial court as reasonably found to have been grossly negligent. But this court will consider an extraordinary writ only when the law has settled and the trial court's duty is absolute. This court should decline Realtor's invitation to use an original action to alter Indiana law. A criminal defendant's Sixth Amendment right to effective assistance of counsel outweighs his limited right to select counsel. The Sixth Amendment to the Constitution guarantees that in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. The essential aim of the amendment is to guarantee an effective advocate for each criminal defendant rather than to ensure that a defendant will be represented by the lawyer where he prefers. As the court has explained, the right to counsel in a criminal proceeding does not mean the defendant has an absolute right to be represented by counsel of his choosing. The appointment of counsel is within the discretion of the trial court and will be reviewed only for abuse of that discretion. The qualified right one owns counsel must be placed against the backdrop of judicial discretion. Traditionally, the courts enjoy broad discretion to determine who shall practice before them and to monitor the conduct of those who do. The Sixth Amendment right to choice of counsel merely informs the judicial discretion. It does not displace it. The trial court is granted considerable discretion to remove counsel so that the trial court has the tools to preserve an accused Sixth Amendment right to competent and effective assistance of counsel. The court has explained that the trial court must be given latitude in its efforts to navigate the scylla and shoe posed by the conflicting Sixth Amendment rights to counsel of one's choice to competent counsel. We conclude the trial court discretion is necessary because of the tension between these two important rights that must be resolved by the trial court. Gross incompetence or continuous conduct that cannot be cured by the citation for contempt may justify the court's removal of an attorney even over the defendant's objection. Moreover, the trial court need not delay taking remedial action until counsel's incompetent representation causes the entire trial proceedings to be constitutionally defective. We must remember the reversals are but palliatives. The cure lies in those remedial measures that will prevent the prejudice at its inception. Affirming disqualification of defense counsel on grounds that the trial court has an obligation to foresee problems over representation that might arise at a trial and head them off beforehand. The trial court retains the discretion to remove counsel to preserve an accused's constitutional rights to effective assistance of counsel and due process. Respondent acted well within her discretion to remove Baldwin and Rozzi over realtor's objections. The record supports that the trial court could reasonably conclude Baldwin and Rozzi committed multiple violations of the rules of professional conduct, compromised realtor's defense, and that the totality of the circumstantial demonstrated gross negligence and incompetence on the part of the defense team. Baldwin and Rozzi failed to take reasonable steps to safeguard confidential case materials, including crime scene photos. Professional Conduct Rule 1.6, Comment 16, Indiana Professional Court Rule 1.15a. Baldwin's friend and former employee, Mitchell Westerman, who we've talked about on previous videos, went into Baldwin's office conference room, reviewed confidential photos of the crime scenes, took pictures of those photos, and shared them with at least one other unauthorized person. The photos leaked to the public which prompted the police to investigate. An individual with whom Westerman shared the confidential photos deleted himself the night after police questioned him. Rosie and Baldwin agreed to use Baldwin's conference room as home base for confidential case materials. Records Volume 1. Rosie understood that Westerman would regularly visit Baldwin's office and that Baldwin would share with Westerman information about the case to obtain Westerman's feedback. But isn't that supposed to be confidential between lawyers? I'm a little confused about that part. Someone doing... They should be disbarred. Utter disgrace. How do you feel about the judge, though, James? Do you think she's being ethical all the way through? So we get rid of the lawyers. Do we continue with that judge? Or do we continue with the lawyers that they started with? Or do they go back? What do they do here? It sounds like one of those lawyers is very, very close to the judge. Like very, very close. And he's from a different county. Both of them are from a different county. So are they the fit that they need? Should the judge be getting buddies to run the case? Because they are buddies. We've seen the paperwork. The judge has lost her way, but the judge runs the court. Keep the February date. Yeah. I'm going to have a little hydration, friends. Good to see you, Dave. I'm sorry if I missed anybody. My nose has been in this file. It's disgusting what's been going on here. It just is disgusting. The whole thing is an ish show. And the people that are suffering are the families. Hey, I seen that, Mexi, that dude from Long Crime years ago talking about how he had 3 crime scene photos. I seen that. I did. Where did he get those from? So we have to also remember there was also, like, it wasn't law enforcement that found the girls. So were these people just, the general people who live in that area, were they snapping pictures? I freaking hope not. I take great offense to that. Upset with both sides. Absolutely. Okay. Okay, so Baldwin emailed confidential work product to an unauthorized person, and Baldwin and Rosie failed to timely report the leak to the trial court or the prosecutor. The leak of crime scene photos was not the first time Realtors Council were involved in a leak of confidential case materials. In December 2022, Baldwin sent an email to a person named Brandon Woodhouse, a defendant in an unrelated criminal case. So he sent him information that contained an outline of the discovery materials the state had provided to Baldwin. So this just went to some random guy, a defendant. So a possible criminal. It was a typo, or he was trying to put in one name and this name, so it got sent to the wrong person. So Baldwin apparently intended to send the email to Rosie. Baldwin and Rosie did not promptly notify the trial court or the prosecution of this leak. Baldwin and Rosie made extrajudicial statements that a substantial likelihood of material prejudicing the case. Indiana Professional Conduct Rule 3.6. Baldwin and Rosie issued a press release November 29, 2022. They included in their press release detailed extrajudicial statements about the case, along with other information that would not normally be revealed, and proclaimed realtors' innocence. Baldwin and Rosie did not limit their press release to information that Rule 3.6b expressly permits, nor did they confine the press release to information necessary to mitigate adverse publicity under Rule 3.6. Ooh, I'm having a hard time catching my breath. Just give me 2 seconds. Oofta. Okay. I think I got this. Okay, let's see here. Baldwin and Rosie knew or should have known that the press release potentially violated Professional Conduct Rule 3.6. Moreover, at the time of the press release, Baldwin and Rosie knew that the state had filed a motion for a gag order, which was pending before the trial court prior to issuing the press release. Baldwin and Rosie assured the trial court that they did not intend to try the case in the media. Baldwin and Rosie's decision to issue a press release prompted the trial court to issue the gag order until further hearing. Baldwin and Rosie issued the press release knowing that the trial court would likely soon issue a gag order. So, but there wasn't one, right? Even if one was coming, wouldn't that have been the time to do it? So what it sounds like, James, is it sounds like Baldwin was on a phone call and was deep into this phone call doing whatever he was doing. And in the meantime, Buddy opened the door and went into this room. He realized he was alone and started snapping pictures. I mean, yeah, Baldwin's has to be held accountable. We know that the other guy, he's been arrested. He just gets like minor charges for taking these pictures and putting them out, which I find ridiculous because the second person that the guy stole them, he passed them on to another guy who got a visit from the cops, freaked him out, and he unalived himself. He was from the military. He was like operations possibly. I'll have to double check. Had a family, young guy. So Baldwin and Rosie proved false information to the trial court. On or about June 20th, 23, the trial court held a hearing on a realtor's motion to reconsider the safekeeping order. At the hearing, the state presented evidence that clearly demonstrated the falsity of realtors' claims. On July 19th, 2023, The court issued an order for the motion, finding that the evidence presented at the hearing did not support many of the allegations advanced by the defendant. Counsel, in fact, the evidence presented demonstrated that the defendant is treated more favorably than other inmates housed at the Westville Correctional Facility. The only thing that I have a problem with that is he is literally in, like, I don't know if it's a max or a super max, but he's in a prison. I mean, he's not in jail. He's hanging out in a prison. I don't know how that works. Someone mentioned it during the last live stream when we were talking about Alex Murdaugh. Somebody basically mentioned, how Koberger has got such a good team, and look at what Richard Allen's going through. A good team, I don't know, but this is unreal. It's like, what? What? As a result of these events, the trial court became gravely concerned with realtors' rights to have competent, non-negligent representation. The record demonstrates that the trial court, based on the totality of circumstances, could reasonably conclude that the council's representation of the realtor fell objectively short of the prevailing professional norms, and that counsel's deficient performance prejudiced the defense in violation of the realtor's Sixth Amendment right to competent counsel. Counsel is effective where 1. Counsel's performance is deficient based on prevailing professional norms. Counsel is ineffective where the deficient performance prejudices the defense. The personal norms in Indiana are violated when counsel fails to safeguard confidential case materials, provides false information to the court, and makes extrajudicial statements that are likely to prejudice the case. And respondents filing complaints against Baldwin and Rozzi with the disciplinary commission would not have ensured the realtor would receive competent representation throughout the remainder of the proceedings. The trial court's decision to remove Baldwin and Rozzi did not violate the realtor's Sixth Amendment rights. I still want to know why Rozzi. Why? Because he works with them? Like, weren't they just kind of mashed together and said, here, you guys are going to go work on this case? Wow. Just wow. What do you guys think? They knew they had specifically talked about the heart's in the way from day one. They have both to blame. Okay, yeah. Talked about the media from day one. Okay. Rise as a team, fall as a team. Realtor argues that removal proceedings should occur at a hearing where the defendant has chosen counsel, are provided notice and an opportunity to be heard on why the attorney-client's relationship should be severed. Realtor cites no Indiana statute, or case requiring notice, a hearing, or an opportunity to be heard. In any event, the record confirms that respondent provided realtor with ample notice. The trial court was considering disqualifying Baldwin and Rozzi before October 19th, 2023. On October 11th, 2023, Realtor wrote a letter to respondent requesting Baldwin and Rozzi continue to represent him and acknowledging that the prosecutor was seeking Baldwin and Rozzi's disqualification. On October 12th, 2023, Rozzi wrote a letter to respondent arguing why he and Baldwin should not be disqualified. On the morning of October 19th, 2023, an attorney representing Baldwin filed a memorandum regarding possible disqualification and sanctions. Realtor had adequate notice and opportunity to argue against respondents' disqualification of Baldwin and Rozzi. Baldwin and Rozzi also had the opportunity to proceed with the scheduled court hearing on October 19th, 2023. Oh my God. Okay, I have problems with some of this though, but chose to withdraw instead. Didn't, okay, I mean, didn't she say if they did not leave, she was going to basically embarrass them on the record in court? Isn't that the way it went? Oh my goodness. You know, where I get really disappointed is Oh, you're welcome, Melissa. It's been a busy day, hey? I'm glad you're enjoying it. Um, I don't know. Baldwin and Rozzi going, I get it. I mean, okay. But do we keep the judge? Do we keep her? Like, in my mind, it's just scrap everybody. I hate to say it. Then they have to figure out what they're going to do with Richard Allen. But I honestly think knew everything. Do you know what I mean? So let's see here. So at an October 31st, 2023 hearing, Baldwin and Rozzi further argued against their disqualification after filing new appearances, and the trial court afforded them an opportunity to be heard on the record. I just didn't see it that way, but including via Baldwin's counsel, record, the trial court afforded Realtor adequate process. Oh, very fishy defense. Like, I get that. I get it. I just, this judge, guys. I have so many. Okay, would you want to be, would you like to come up against her? Ay, 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 Chihuahua. Yeah, she basically strong-armed them and closed chambers to step down, or she was pulling their pants down in front of everyone. Yeah, well said, Dandy. So, I mean, okay, they gotta go. I'm still unsure about Rozzi. Still unsure, but let's just say they go. She needs to go. And I also think Slick Nick needs to go. It's just my personal opinion. It's and then they can figure out what the hell to do with Richard Allen. They're gonna have to get him out of that place, that's for sure. If they're gonna take another year, they can't leave him in that place. He's gonna look like a twig again, like a very unhealthy twig. Remember? Like, oh my God, oh my God. And I mean, when he went in, he was a chunky monkey, you know? He was healthy looking. Yeah, I just think that they all need to go, and then they can figure out to do what they have to do with him, but I don't trust any of them anymore. I'm eating steak, baked potatoes, and Mexican corn. Oh, Melissa. Nice. Realtor's assertion that respondent must be disqualified because she removed realtor's former attorneys is flawed. First, Baldwin and Rossi no longer represent realtor. The realtor does not assert that the respondent has any personal bias or prejudice towards himself or his current counsel. No, because she goes out for lunch with them, sends Christmas cards, chat on the phone, allegedly. Second, on the merits, realtor presents no relevant facts supporting realtor's assertion that respondent is biased or prejudiced against realtor's former counsel. Judges have affirmative duty to preside over cases unless disqualification is mandatory. A judge shall hear and decide matters assigned to the judge except when disqualified is required by Rule 2.11 or other law. Disqualification is mandatory in the rare instances the judge displays a personal individual bias against the litigant. So she's not saying, like, this paperwork is not saying that she's basically saying in code, I guess, that she didn't really like the last lawyers. That's kind of what I'm reading between the lines. But what do you guys think? Doesn't have a problem with the current lawyers that she goes out for pizza with. Okay, so let's see here. Moreover, as a commentary to the Code of Judicial Conduct, emphasizes a judge's unwarranted disqualification compromises the system of justice. Unwarranted disqualification may bring public disfavor to the court and to the judge personally. The dignity of the court, the judge's respect for fulfillment of judicial duties, and a proper concern for the burdens that may impose upon the judge's colleagues. Colleagues require that the judge not use disqualification to avoid cases that present difficult, controversial, or unpopular issues. Whoa. The law presumes a judge is unbiased. Oh, you'll get a cookie. She's sitting there, her little front paws are crossed. Well, not so little. Her front paws are crossed. She's sitting there with a big sad face and crying because she wants like a treat. Actually, you know what they like? Temptations. The little cat treats. Sit down, ladies. Sit down. Has it been a long day? Have you guys been ignored? Okay. The law requires a judge is unbiased and unprejudiced. Judges are presumed impartial and unbiased. To overcome this presumption, realtor must demonstrate actual personal bias. Actual bias or prejudice exists only where there is undisputed claim of judicial bias or judge has expressed an opinion on the merits of the controversy before her. Adverse rulings and findings by a trial judge are not sufficient reason to believe the judge has a personal bias or prejudice. The mere assertion that certain adverse rulings by a judge constitute bias and prejudice does not establish the requisites showing. Respondent removed Baldwin and Rozzi from presenting Realtor on October 31st, 2023. Respondent appointed new counsel Robert Scremin and William Labrato to represent Realtor. Realtor is presented in this original action by Mark Lehman and Kara Weinick. Realtor accuses respondent of exhibiting bias or prejudice exclusively towards Baldwin and Rosalie. Realtor never suggests that respondent is biased or prejudiced against Realtor or his current counsel. Yeah, I gotta have a liquid, guys. That's kind of what I was thinking. Like, is she admitting to not really liking Baldwin and Rozzi? The pups love justice. Yeah, they're my little true crime buddies. I love my zoo. Even if Baldwin and Rozzi still represent Realtor, respondent has exhibited no actual bias or prejudice against them. Realtor offers a scant 2 sentences to support his assertion that respondent has exhibited bias or prejudice. According to Realtors, respondent's findings that counsel were grossly negligent and publicly proclaiming that she'd had grave concerns about their representation warrant respondent's disqualification, but a judge's findings adverse to a party do not show or even imply a bias or prejudice. Further, these findings do not demonstrate actual personal bias. Respondent did not state that she had grave concerns about Baldwin personally. Rather, she had concerns only about their representation of Realtor. What? What? Rather, she had concerns only about their representation of Realtor and his rights to competent. Respondent did not state that she had grave concerns about Baldwin and Rozzi personally. What? Rather, she had concerns only about their representation of Realtor. Yeah, okay. And his right to competent representation. So one thing I will say about these 2 lawyers, I mean, yeah, there's a screw up. There's a bad screw up all the way through this court, from the judge all the way down. I mean, it's a shite show. But some of the things that are being said in these documents, I have to disagree with. Further, these findings do not demonstrate actual personal bias. Respondent did not state she had grave concerns about Baldwin and Rozzi. So, respondent's legal findings regarding Baldwin and Rozzi's representation are insufficient to overcome Indiana law's presumption that respondent is unbiased and unprejudiced. Realtor requests this court to reinstate the January 2024 trial date, but Realtor's counsel requests the trial continuance because counsel will not be ready to try the case in January. This is where we start running into more problems. Respondent did not violate an absolute duty by granting Realtor's own motion. Amicus Indiana Public Defender Counsel, IPDC, argues that the trial court's appointment of Realtor's current counsel was procedurally defective, but Realtors raise no objections to the respondent's process for appointing new counsel to replace Baldwin and Rozzi. Amicus may make arguments in support of realtors' request for relief, but the court should not entertain amicus separate relief requests for relief. Neither IPDC nor realtor assert the realtor's newly appointed counsel, one of whom, as the IPDC notes, is Allen County's chief public defender, is incompetent. The IDPC merely claims that the trial court circumvented the county's comprehensive plan for public defender assignments. However, the trial court has discretion to appoint counsel other than counsel provided under the board plan when the interest of justice require. The trial court's method of appointing realtors' new counsel did not violate Indiana law, the Sixth Amendment, or any other absolute duty under the law. So the conclusion, respondents, the Honorable Francis C. Gull, respectfully request that this court deny realtors' verified petition for writs of mandamus and prohibition. Attorneys for respondent, the Honorable Francis C. Gull, Special Judge. Pursuant to Rule 3B, the Indiana Rules of Procedure and Original Actions, undersigned counsel certifies that foregoing contains fewer than 4,200 words as counted by word processing data system used to prepare the brief. All right. Holy shite, guys. Holy shite. What do you guys make of it? What the hell is going on? What do you guys think? Respondents' legal findings regarding Baldwin and Rozzi's representation insufficient to overcome Indiana law's presumption that respondent is unbiased and unprejudiced. Yeah. What the hell is going on? I think we're going to see more documents. I think we're going to probably see a little bit of a document fight go on is pretty much what I'm thinking. So yeah, that was Gull responding to, I'll have to take another look. There's so many documents. It's like, what the mother, to keep track of all of these different cases. I'm doing not too bad, but some of these cases have got hundreds. This one here, I remember a document dump of 108 documents. So I don't know. I'm going to be curious, like, what the hell's going to happen here? Yeah, what's crazy is one of the new lawyers have already spoken publicly about the case. It's just what? Yeah, have already spoken publicly. Why doesn't she just say discretion? Why does she have to? Oh, yeah. Do you know what? Legal mumbo jumbo. Oh, my God. And the thing is every single little word that is in there means something. You know, sometimes getting a document and trying to figure out what they're actually saying. It's like, what? Airwolf, Teen Wolf. Let's see here. This case needs to be 99.99% accurate before it gets to the jurors. It has to. No one could go through this crazy again. Yeah, well said. Well said. Wasn't he saying that he believed the ballistics? Hey, ladies. Hey. That's what I'm afraid of. I think the new attorneys are going to be like lap cats to the judge. It's these huge words and numbers. In the end, it means, yep, agreed. Why? Seriously? Yeah. Yeah. Here's a question. Can the state use that against the defense in court? Upsetting the judge? Most unwise. Oh my God. So I don't know. Personally, I think start over. I don't know how they can do anything else and have it fly. There will always be questions if any of the same players are involved, including the judge. They need to start right the hell over. Who the hell's going to believe anything these guys say when all we've heard the last while is like BS? Pure BS. They have literally said nothing. It's true. It's true. Yeah, James, you don't upset a judge can upset anybody else and everybody else, but you can't upset them. Weird. Yeah. Anyone but the judge. Oh, I got a story one day. I got so many stories, guys. So, again, I think we're caught up on the paperwork, but I would expect we're going to start. My girls are starting to wrestle. I do believe we're going to start hearing a little bit more. When that happens, we'll do the same thing. We'll jump on and we'll do another live. So thank you very much, everybody, for joining me. Ladies. Yeah, thank you very much for joining me. I appreciate it. It's been a long day. You guys have been awesome. Awesome. And I'll absolutely see you guys in the next one. Bye.